start. Okay, welcome everyone. Today we have our guest Paulina from GJW presenting Law and Art. Please be respectful of our host and everyone present. And Paulina, please share your screen and take it away.
Welcome to today's seminar, to today's meeting. As I was preparing to today's meeting, I was trying to think how to design the message for you regarding that legal issues are not the easiest one, and they are usually not so interesting. So I decided to put the information in 4 basic points. And at the beginning, we will discuss, and I would like to tell you about the artist's rights as an example of intellectual property rights. I will show you what the intellectual property rights, what means and what they really are. I will try to explain a general legal system regarding IP, and I will talk a little bit about the forms of IP. And the next thing I would like to tell you is the artist's duties, and I'll give you the basic checklist of obligation. I will tell a little bit about art contracts that are essential in any activity, especially the artist activity. And at the end, I will say a couple words about infringement of law of artists and possible remedies. Okay, so as an introduction, I could tell you again, my name is Paulina. I am an attorney at law and also the partner of Guildhall Legal Office. But I also represent today the Guildhall Gallery. That is actually the activity that is pretty different than my everyday profession. And as a gallery, Guildhall Gallery, we are, among others partners, we are a partner with Victory Arts in a common project to create greater awareness of Eastern European art. And as you maybe are aware of, this project enables the artists from various countries to get the adequate training, which they would not normally have access to if unpaid. So I'm really glad that I could be a part of this project. And as I mentioned, the gallery project is, I'll tell you a few words about our project, is the project of Igor Morski, that is the Polish artist and graphic designer and press illustrator, and my legal office. We created the website under which one we decided to share the virtual exhibitions of Igor's work. So you can all visit it under www.guildhall.gallery. And just to give you the quick review, the gallery of works in the climate of sort of realism and hyper-realism is associated with the art conveying a hidden message, and this is the style that Igor is known. And by having this perspective, like being a lawyer and then working in this field of art, I think it's very direct example of law and art. Okay, so cooperation between the law firm and the gallery, I guess, offer the opportunity to promote, but also, and above all, give the full protection to the artist of his rights. So that's pretty interesting perspective. Oh, and I wouldn't be a lawyer if I didn't say that. This is really main disclaimer for today. Before we begin, I would like to notice that this material is not to be taken or construed as a legal advice. And if you need one, you just you'll have to use some professional legal advisor, but as I mentioned, forming today's message for you, forming my speech today and performance, I made a basic assumption, and this disclaimer is related with this. I will not refer to any particular national law. My aim and goal is to give you the general and basic refer how the law would look like in general legal system and every system. So to give you the general knowledge about what we are going to discuss here today. Okay, so let's begin the proper message. So what is important here to give you as the artist the information about your rights, and the most important information is that artist rights are example of intellectual property rights. So famous IP rights, I think everybody heard about IP rights in the past or met with IP rights in some documents and so on. And in general, like definition of intellectual property is that this is an umbrella term for a general, the group of legal monopolies covering intangible property associated with the human creative activity. So that's what it says. And general IP law deals with law, specific law to protect, and that's the aim and goal of this protection, and enforce the rights of creators, no matter what kind of piece of work they create, okay? And also the owners of inventions. And in this box that called intellectual property, there are several areas of intellectual property that are most common and famous. And there are three of them, three primary types, you could say. It's just patents, it's copyrights, and it's trademarks. And also we have several more like trade secret, like industrial property rights. And these are all specific legal areas that also serve for the different purposes and also covered by different legal documents, for example. And talking about intellectual property legislation, as I mentioned before, I will not give you the specific description of any or national laws. I just will give you the big picture, okay? So general laws vary between the countries, and that's maybe the truism, but it's worth underlining here. And it varies across the European Union and the world. But while many countries have laws which are pretty similar in many respects, the details, of course, may vary. The details, what is and what is not legal, may vary in specific countries. And when I was mentioning you about the forms of IP, about the, let's say, the ingredients of this great and huge box that is called IP, we have to mention that these forms of IP are also covered by the national laws, as well as the European Union legal system, and also the global treaties. So talking about national law, we need to indicate that probably every country has regulation that are connected and related to the IP rights. For example, copyrights, we have like in a couple countries that for sure they have the copyright regulations. It's France, it's Germany, it's Ireland, it's Italy, it's Netherlands, it's Poland, Romania, Spain, Sweden, United Kingdom. So we know that in these countries that kind of protection exists. And also, for example, in Poland, we have a special treaty for industrial property rights for the trade secrets. So I believe in any country it is built in the same same way as talking about legislation. We have also the works that treaties that works worldwide, and it's, for example, Berne Convention, it's Lisbon Agreement, Paris Convention for the protection of industrial property, and the Berne Convention was, for example, ratified by almost every country in the world. So we have huge legal achievements regarding IP rights. We have huge European legal achievements regarding copyrights. For example, we have almost over 14 directives. So this is really a rich field of information. So deriving forward, we could and we should start discuss about copyright. This is the most popular form of intellectual property, and the copyright is this is the definition of it. It is an exclusive legal right for author, creator, or author who create original work. This is very important word, original work, which allow them, authors, to protect their creative work, such as painting, design, music, anything they could create, to protect for a specific period of time. And generally, this protection is available for both published and unpublished works. Copyright is an asset with a value, so that in result is observed by almost all or most country. As I mentioned about the Berne Convention, almost every country ratified the convention. So what here is all about is just to create the worldwide requirement. Okay, so they should apply. So in this situation, we treat everybody the same. So the copyright for citizens are treated, or supposed to be treated, the same way in every country. So continuing about copyrights, what they really mean and what they bring it with itself. Copyright means that the artist has the right to be recognized as and listed as the author of her or his work in a particular piece of work, not other particular piece of work. And what is really important here is that copyright cannot protect a concept or idea. Well, you can have idea for drawing, painting, or other work, but you cannot copyright it until you produce it. So the protection starts from the time that work is fixed in a tangible form. And what is related with copyright is that you do not need the registration of the copyright, although it's not necessary, although it's possible in some countries and in some legal systems. And it's another rule here. So when you work in joint venture with some other artists, when you created some work jointly for a couple artists, all are co-owners of the copyrights, of course, unless otherwise specified in a certain agreement. And in the case where an artist has created the work, this is another rule. It has created the work while being employee. The employer is considered to be an author and the copyright holder. And what else? The mere ownership or transferring of a painting, drawing, another form of work, it does not convey the copyright, and also does not mean that you can change the material in the object that was once created. And these are two very important issues related to the copyright. Copyrights can be transferred and licensed to the third parties, for the purposes that was established between the parties within the specific terms. So you can fix those terms together with the financial ones. And also important rule that copyrights continue for the specific period of time after your death, and the term of copyright protection varies from country to country as determined by the national legislation. And terms of copyright protection can be different worldwide, although the basic rule that's the copyrights last for the lifelong, and then after life, like for 50 and more years, 50 to 100, for example, almost whole Europe. I'm looking at the map of term of copyright protection. And when I look at the map and the Europe, I see that this is the protection lasts for life of artists, and also, let's say, for 70 years, a little bit more. Okay, and here are some other competences that are available to artists. They're somehow related with copyrights, but still that could be treated differently in specific legal system. And you have resale rights, and you have rights of publicity, and you have also the moral rights. And the first is resale rights, that they stipulate that artists may financially participate in a commercial resale of their original work of art. And this situation was harmonized by the European Union, for example. We have a resale rights directive, and the directive stated, that this is the right that is personal to the artist and can be only transferred by inheritance. And the basic idea of this document is that it is calculated, this right is calculated as a proportion of this resale price, which varies between 4 or 5%, and the total royalty that is for the artist is limited at a certain point of money, that is 12,000, over 12,000 euros. Okay, and rights of publicity. This refers to an individual exclusive right to authorize how to name or voice signature maybe look like. The artist's right of publicity must be cleared with the artist if someone would like to use it, right? And the last one, moral right, in some legal system, it could be called like personal rights or personal copyrights, like in Poland, for example. This is the rights of an artist to maintain the integrity of work, but it reflects personal interest in the work, and usually is attributable to the author, and it's not transferable like copyrights, for example. In Poland, we have copyrights that called material copyrights, and let's say moral rights or personal rights, and the first one could be transferred, and the second one cannot be. So as you see, the system looks like pretty the same, I think, in every legal system. Okay, so that's I think I finished the part of the knowledge and rhetoric. And now I prepared some artist duties, and these are the basic checklist of obligation, and this is rather a more practical tips and hints for you. Generally, I have that kind of advice that you should educate yourself on legal aspects and understand the rights and legal obligation under the laws that you are working with, that you are that you're making business in, or maybe when you, I don't know, have any transaction with other countries. So try to get known all that regulations. And it's education is also protection. So I think it's rather important. And protect yourself by having a contract with a third party. And when you are entering into such contract, whether it's explicit, whether it's written down, or whether it's implied. So try to understand not only the legal details that may be really hard to understand sometimes, but also other arrangements, especially financial. So be sure what kind of transaction you are doing, what is the subject of transaction, just be aware what's going to happen in this relation between the parties. And it's similar advice when you do not have agreement, but you maybe have fixed terms that you're gonna be connected with. So make sure you obtain and you understand the written conditions of entry, which you may be asked, for example, to agree before they send you work to the, I don't know, exhibitions, some festivals, some art prize, or other competitions. So always some rules and regulation exist, even though nobody is interested in this, but they still can be they are binding, and it's also will be related in this situation. In any transaction, in any situation, when you are involved, you are, as an artist are involved with, just try to check the seller's reference, check other side counterpart of the agreement. And this is my general advice as a lawyer. I agree, advise in such a way to any clients, and it doesn't have to be in the art field. It could also be the business field or anything else. But if we go to the freedom of contracts, if we go to a contract, this is my still advice. And anytime, if you have any problems, if you have any doubts, you should get a qualified legal counsel at any time. I guess the sooner is the better. And I'm saying this in my perspective, in the perspective of someone who is legally working with the clients and know their situation and problems. I can assure you that the soon someone could help you, and this is the better for the whole situation and for the legal situation of the artist. And this is the other part that I provided for you today, is that I want to talk about and discuss. This is art contracts, and I'll just depict you the general regulations and standard typically applied in such documents. Of course, every contract, every agreement depends on the type of transaction, and every contract, I believe imagine vary in specific countries. Okay, any contract that is written down under some national law could look like little differently, but still, as I revised during my experience or career, as I revised like thousands of them, not only from my field, let's say, but also some other contracts from other countries, the United Kingdom, Scandinavia, or Italy, or Germany, or East Europe. every time more or less the same. They have like similar idea of dealing with transactions. So when we talk about agreements, we can have like copyright transfer. We can have like copyright licensing. We could have gallery or agent contract, or we could have a contract with influencer and many others. And typical agreement content, I believe it's subject of agreement, goods description, is copyright notice, is conditions of cooperation, sale price, the way of pricing the good, warranty, and other business information. And still all these ingredients, let's say, depends very much what kind of agreement you are going to sign. But usually it's going to be the matter of your advisor, of your lawyer maybe, but still you could and you should have like general knowledge what you should be careful with. And as we could just quickly describe all these moments. So when we talk about subject of agreement, it's important to have a fixed description of what we want to do with the other side, how we want to deal with this transaction. And it's also important to have a good description. We can make a description in the middle of the contract, but as well we could make some appendix where we have our works. For example, if we have a paintings or another kind of work, we can have like specified material and the date of making the work. We could have a price, also an appendix. I guess the more details we put inside, it's usually the better for the both sides. We also have a conditions of cooperation. This is especially important when we have cooperation with the agent or gallery, when you have as an artist. So when you expect from a gallery or that kind of body to help you in something, to prepare to do the exhibition. So this is very important to have the obligation detailed so that you could later exercise those obligations, and also to await from other party to fulfill his obligation. General another gold hint, I guess, that's it. Remember, no matter if you will work through your agent, through let's say lawyer, or by yourself, any agreement should be a matter of negotiations, and the counterparty of the agreement has the right to draft it, to amend it, or to modify the agreement. So in a meaning of freedom of contract, you should always act like towards the situation that the agreement is showing your real intention, and that you are agreeing to every conditions of it. Okay, and I know that negotiations are not easy thing for many artists, but not only the artists, also for the businessmen as well. And especially are the artists who are just starting out, but still, this is referring also to another people. But what is important, that becoming a good negotiator is more a matter of experience than anything else. So it's just the same like talking to people or performing your informational speech in the webinar. So the more you do it, the better you feel. So I am sure that same is with negotiations here. Okay, and I think these are the last part of information I have prepared for today. This is infringement of law of artists, and just a couple information here. Infringement may apply directly to the author's basic entitlement. I think here about the copyright, of course, or also maybe connected or may apply to the contract that author entered into. So when I think and when we think about infringement, we should imagine that infringement could mean the large situation. Okay, so copyright infringement usually occurs if there is an unauthorized use of the exclusive right of the owner. And no matter if we think about substantial part or whole copyright work, and it happens, the infringement happens when copyrighted work is reproduced, distributed, performed, publicly displayed without the permission of the copyright owner. That's the basic situation when it's something wrong with a copyright. And again, a breach of contract may occur when any party in a binding agreement fails to deliver according to the terms of the agreement. Saying any party, of course, I mean the other party, the artist. So this is the situation when the gallery, any advisor, agent does not fulfill their obligation. The example might be that someone failed you to pay as the artist for your work or for the services, when he failed to perform, or when he do the incorrect execution of other works. So maybe he do, but he not doing it properly in the meaning of the contract. And
hi, we have 3 minutes and 30 seconds left. Is that doable? Yeah.
Four more things to say.
Perfect. Yeah, thank you very much.
Possible remedy. Okay, in both cases of violation of rights or contract, you of course can try to terminate the infringement, or you may just consider to suing the infringer. So you may have or you may try to do the prejudicial phase, but when it's not possible, you just have to go to the court and try to seek the damage in court. And depending on the situation, if there is a possible legal infringement or the rights of agreement, it will be necessary to determine somehow the applicable law and jurisdiction. That is pretty important thing, but I guess this is more a hint in my perspective. So the lawyer perspective. Okay, and as I advised you earlier, get the legal services and search remedy whatever you feel discomforted and you don't feel free in the relation. You could always try to find non-profit organization that will provide access to the free or low-free legal services, so that you can feel comfortable in your situation as an artist. Okay.
But anyways, go check out the GJW, guys. The gallery is beautiful. And I would like to say that this was sponsored by Visegrad. And yeah, thank you very much, Paulina, for coming. And it was very insightful to have this whole presentation and overview. So
okay, great. Thank you very much. And if you need, and if you have any need for contact, you can feel free and contact with us. And also, I would like to thank you also for the joining tonight and for the joining us. Thank you very much.